So I have 40 test questions for you related to the transfer of property. This is a compilation video. It'll be broken out into a 10 question segment, another 10 question segment, and a 20 question segment. Okay, let's start with these 10 questions. So question number 1, which of the following indicates the tearing away of land by the action of water? A, avulsion, B, alluvium, C, accretion, D, accession. Correct answer here is A, avulsion. And so this one is just a basic definition. I'm pretty sure I saw this one on my exam a couple years ago. So just make sure you know these basic terms and you'll be fine. Question number 2. When a property is sold by the court and the proceeds are divided among the owners, this is called A, divided interest action, B, reverse action, C, split action, D, partition action. The correct answer here is D, partition action. Partition action is a court proceeding to settle a dispute between co-owners about dividing their interest in real property. Question number 3, what does a title company do? That's a great question. A, hold escrow. B, ensure clear title to real property. C, convey equitable title from vendor to vendee. D, transfer title from grantor to grantee. Correct answer here is B, ensure clear title to real property. Make sure you know what chain of title means. Basically, a title company ensures clear title by reviewing the chain of title. Question number 4, who has the authority to change escrow instructions? A, buyer and seller together. B, the seller. C, the buyer. D, the broker. Correct answer here is A, buyer and seller together. So this one is actually applicable to when you become an agent. You will need to understand that if you want a change, to escrow instructions, all parties need to sign off on that document. So neither the buyer nor the seller can unilaterally change escrow instructions, and no broker can change them. Only the buyer and seller can change them together. So they have to agree and they have to both sign, and they both have to sign the escrow documents to change the instructions. Question number 5, when the loan is paid, who conveys the deed of reconveyance to whom? A, grantor to grantee. B, trustee to vendor. B, trustee to trustor. C, vendor to vendee. D, truster to trustee. Correct answer here is trustee to truster. A deed of reconveyance is used to convey title from trustee to truster. Just, when you're studying, review the chapter summaries, review the terms, and make sure you know what each of these words mean. A big battle when taking these tests is just understanding what the question is asking and what the answers even mean. And to help you with studying, I get this question all the time. People email me all the time. Hey, Darren, where do you get your test questions? I get them from an online education provider called Calibri. If you want a link to Calibri so you can purchase your own, I have an affiliate link. So full transparency, if you buy anything from there, you are supporting the channel directly and you're increasing your chances of passing on the first try. All right, let's finish up the rest of this study session and let's get through these questions. Question number 6, who is the trustee and what title, if any, do they hold? A, the lender who holds equitable title. B, the borrower who holds equitable title. C, the lender who holds bare legal title. D, the neutral third party who holds bare legal title. Correct answer here is D, the neutral third party who holds bare legal title. So as I mentioned before, it's really important to know what each of these words even mean. If you understand what a trustee is and what title is, this will be an easy question for you to answer. Question number 7, which of the following defines a partition action? A, action of water eroding the soil. B, a court proceeding to dissolve a partnership. C, a request for building code variance. D, a court proceeding to sever a joint ownership. Correct answer here is D, a court proceeding to sever a joint ownership. Just remember, partition is the division of an undivided interest in common among the individual owners. So when you hear partition, it means to separate. Question number 8, who acknowledges a deed? A, grantor. B, notary. C, vendee. D, grantee. Correct answer is A, grantor. So a grantor acknowledges that they voluntarily executed a deed in front of a notary. This just means that whoever signs it, they did it in front of another person, a notary. Question number 9. When a person inherits land by intestate succession, how do they acquire title? A. Occupancy. B. Succession. C. Transfer. D. Accession. Correct answer here is B. Succession. So 2 parts to this. The first is you need to understand what intestate succession is. And the second part is you need to understand what each of the answers means. So when a person inherits property as a result of someone dying without a will, that means intestate. You made it to the end. Last but not least, question number 10. In the closing statement required by RESPA, the sales commission is shown as A. Credit to the seller. B. Debit to the buyer. C. Debit to the seller. D. Credit to the buyer. Correct answer here is C. Debit to the seller. So this question might need to be updated because buyers can also pay commission. But still, many times the seller is responsible for the sales commission. And so the sales commission, when paid by the seller at closing, reduces from their net from the sale of the property. So it would be a debit to them. Now that we've made it through these 10, take a quick break, see how you did, review the ones that you got wrong, write it down, and let's hit these next 10. Question number 1. Which of the following statements concerning a settlement or closing statement is true? A. The realtor's commission is a credit to the buyer's side of a closing statement. B. A closing statement is a simultaneous listing of debits and credits to the respective buyer and seller. C. There is a corresponding credit for a buyer and debit for a seller on all charges on closing. D. There is a corresponding debit for a seller and credit for a buyer for all charges on a closing statement. Correct answer here is B. A closing statement is a simultaneous listing of debits and credits to the respective buyer and seller. So you basically just need to know what a closing statement is and what it looks like, and you'll understand that a closing statement just presents a final, detailed account of a real estate transaction. And it lists each party's debits and credits and the amounts each will receive or be required to pay at closing. So this is not like accounting where each debit has a corresponding credit. Question number 2. What is a summary of all useful documents discovered in a title search called? A. Settlement statement. B. Title report. C. Good faith estimate. D. Abstract of title. Correct answer here is D. Abstract of title. An abstract of title is a summary of useful documents discovered in a title search. And this is what they use as evidence in marketable title. So really important with the transfer of property, you understand what each of these definitions mean. Question number 3. A landowner is advised that a railroad company plans to cross their property with a railroad line. Oh, dang. I wouldn't want a railroad going through my house. If the landowner refuses, I would probably try to refuse too. The railroad company can proceed by the use of A. Eminent domain. B. Partition action. C. Accretion. D. Police action. I hope not police action. Dang. Correct answer here is A. Eminent domain. So the law does state that the right to eminent domain to public utility companies allows them to acquire private property for public use, such as constructing a railroad line, provided fair compensation is given. Eminent domain can be a touchy subject because what is considered a fair price for someone's property? I do understand that land is being used for a public good for everyone, but there have been movies and historical cases around eminent domain being not that fair. Question number 4. When the size of beach property increases because of the permanent withdrawal of the sea, this is A. Progression. B. Regression. C. Reliction. Correct answer here is C. Reliction. Reliction just refers to a recession of water from the usual watermark or waterline, which causes an increase in the land. Land which was once covered is now uncovered. So first of all, congratulations if you own beachfront property and now you get more of it because of this. Question number 5. Which of the following is necessary for a valid grant deed? A, acknowledgement. B, legal description. C, words of granting. D, competent grantee. Correct answer here is C, words of granting. So answer D, a competent grantee, kind of feels like it should make sense here. The reason why a grantee does not need to be competent is that they could be a minor, for example. But a grant deed must contain words of granting to be valid. So when you are studying, make sure you go through the definitions at the end of each chapter and understand those definitions very clearly. We're halfway through the questions, and I want to invite you, because I know you're going to pass your exam and you're going to become a successful real estate agent. And so I'm going to invite you to get a weekly email from me where I share my experiences as a real estate agent. I share my wins, my losses, current marketing tactics that are working for me. If you'd like to hear from me every week, go ahead and sign up using the link below. So obviously I want to see you crush it as a real estate agent, but the first step is passing your exam. So let's get back to studying. Question number 6. What is the recorded notice of a pending litigation that may affect the title, clouding the title to prevent transfer? A, attachment lien. B, lis pendus. C, mechanics lien. D, judgment lien. Correct answer here is B, lis pendus. So the recorded notice of the pending litigation is called lis pendens. It serves to notify potential buyers or interested parties of legal action that may affect the property's title. Question number 7. What instrument would be used when the government conveys title to a private individual? A, quitclaim deed. B, patent deed. C, reconveyance deed. D, gift deed. Correct answer here is B, patent deed. And here's the reason. Under homestead laws, when a landowner is given title by the government for making the land productive, they receive a patent deed. Question number 8. On a closing settlement statement, the buyer's mortgage is A, a credit to the buyer. B, a debit to the buyer. C, a credit to the seller. D, a debit to the seller. Correct answer here is A, a credit to the buyer. When it comes to the closing settlement statement, people often think of a mortgage as a debt, but on the closing statement, it's actually a credit to the buyer. This is because it reduces the amount of money the buyer needs to bring to the closing table. So I would recommend when you're studying, spend some time looking over a closing settlement statement and understand from a high level what the closing statement is and what things affect the buyer and the seller. Question number 9. The seizing of property by the sheriff to be held as a security for a legal action is known as A, writ of execution. B, writ of seizure. C, writ of attachment. D, writ of possession. Correct answer here is C, writ of attachment. So a writ of attachment is the process by which the court holds the real or personal property of a defendant as security for a possible judgment pending the outcome of a lawsuit. When you see a question like this, read the answers and think of the definition of each of those answers. And then think about what the question's asking and see if that fits the definition of the answer. Question number 10. What kind of title does the vendee have? A, naked title. B, equitable title. C, quiet title. D, bare legal title. Correct answer here is B, equitable title. So keep in mind, a vendee is someone that's entering into a land contract. When you see the word vendee, think land contract. And when they enter into a land contract, they do not get legal title until the terms of the land contract have been met. Before the terms of that contract have been met, they hold equitable title, which grants them the right to use and benefit from the property. And now that we're about halfway through the video, go ahead and drop a comment and let me know if you like these compilation videos of 40 questions. We're going to end it off with 20 questions. Question number 1. What clause would the lender enforce if the borrower transferred their interest in the property to someone else? A, alienation. B, subject to clause. C, acceleration. D, assumption clause. The answer is A, alienation. So a lender can call the entire note due when there's a transfer by enforcing the alienation clause. Question number 2. The complete history of the ownership of property is referred to as the A, guarantee of title. B, certificate of title. C, chain of title. D, abstract of title. The answer is C, chain of title. Question number 3. Property accumulated by husband and wife by the efforts of either and thus equally divisible at time of divorce or dissolution is termed A, condominium. B, cooperative. C, community property. D, chattel. The answer is C, community property. So A, condominium is a system of ownership of fee simple title to designated areas of airspace and plus a percentage of ownership of common elements in a property. Now, a husband and wife can hold a condominium together, but community property better describes property that's accumulated by husband and wife during their marriage. And so that's what makes it equally divisible at the time of divorce. Chattels are just personal property, which are not real property. So that wouldn't be applicable here. Question number 4. A standard form of title insurance policy does not protect against loss resulting from A, forgery in the chain of title. B, lack of capacity of the grantor. C, encroachment on the property. D, liens and encumbrances of record. The answer here is C, encroachment on the property. So title insurance protects everything related to public record. Anything not of public record is not covered. So in this case, a forgery in the chain of title, definitely protected. An encroachment is the intrusion of a physical object onto the property. Question number 5. Standard title insurance covers A, all title defects. B, defects disclosed by a competent survey. C, recorded title defects. D, unrecorded title defects. The answer here is C, recorded title defects. Question number 6. At what point does a deed transfer a grantor's interest to a grantee? A, when the grantor signs the deed. B, upon delivery to and acceptance by the grantee. C, upon recording of the deed. D, when the title insurance is issued. The answer here is B, upon delivery to and acceptance by the grantee. So a deed actually does not need to be recorded to affect transfer of real estate. When the deed is delivered to the buyer and accepted by the buyer becomes the owner of the deeded property. Question number 7. In a real estate sales transaction, title to real estate passes from the seller to the buyer by A, possession of the property. B, all of the answers. C, execution of a deed by the seller and delivery to the buyer. And D, recordation of the deed. The answer is C, execution of a deed by the seller and delivery to a buyer. So I just went over this in question 6 as well, but a deed technically does not need to be recorded to affect transfer of title. Question number 8. The promise in a deed that the seller is the owner of the property and the buyer has the right to possess it is known as A, covenant of cession. B, covenant against liens and encumbrances. C, covenant of quiet enjoyment. D, covenant of warranty forever. Boy, would I love a warranty forever on all of my appliances. The answer is A, covenant of cession. Really important for these types of questions, just understand the definitions of each and you'll be able to nail these questions. Question number 9. The real property which is subject of a trust deed is considered to be A, collateral. B, security for the debt. C, a mortgage. D, evidence of the debt. The answer is A, collateral. So a promissory note, which is the evidence of the debt, is backed up by the collateral, the real property, which can be sold according to the terms of the trust deed, which is the security instrument. Question number 10. A written instrument transferring the grantor's ownership of or interest in real property is known as A, title. B, easement. C, mortgage. D, deed. The answer is D, deed. So once again, if you just understand what each of these words mean, you'll be able to quickly and easily answer these questions. So we know that an easement is just the right acquired by one person to use the land of another for a very specific purpose. And title refers to the actual ownership of a property, while a deed is not title. So we're halfway through the 20 questions. Before we go any further, I want to invite you to purchase your own test bank of questions using Calibri. So full disclosure, I have an affiliate link, and when I make these videos, I get the questions from their test bank. I personally use them to pass both my real estate exam and my loan officer exam. So if you want your own test bank of questions for your state, go ahead and use the link. Okay, back to the questions. Question number 11. Title to real estate is transferred when a deed is A, acknowledged, B, recorded, C, delivered and accepted, D, signed. The answer here is C, delivered and accepted. This is the third question related to title and deed and when is title actually transferred. So if we haven't learned already, the transfer of title occurs when the deed is handed to the buyer and the buyer accepts. Question number 12. Actual notice refers to A, the information you are presumed to know. B, something you have actually seen or know to be true. C, the reasons why you should record a deed. D, documents that are recorded at the courthouse regarding a person's property. Correct answer here is B, something you actually have seen or know to be true. Question number 13. A quit claim deed conveys only the interest of A, the grantor, B, the vendee, C, the grantee, D, property. The correct answer is A, the grantor. So the grantor and the grantee are parties to a deed, and a quit claim transfer deed transfers the interest of the grantor only. A grantee does not sign a deed, and a vendee is a buyer in a land contract. Question number 14. A valid encumbrance affecting title of estate and land, such as mortgage or judgment, is called A, contract for deed, B, chattel mortgage, C, cloud on title, D, condemnation. The answer is C, cloud on title. And so a cloud on title simply means that the property is not clear from all liens. A cloud could be mortgage or judgment. And a chattel mortgage is a mortgage against personal property, not against real property. If we go back to an earlier question, we know the definition of chattel is personal property. Question number 15. The word escrow may refer to A, money deposited in the bank and subject to depositor's withdrawal. B, transfer of a deposit from salesman to broker. C, a safe deposit box where a deed is placed. D, the deposit of legal documents with a third person for future delivery. Correct answer here is D, the deposit of legal documents with a third person for future delivery. Question number 16. What clause allows a buyer to take over a loan, making payments without the lender's knowledge and consent? A, acceleration. B, subject to clause. C, assumption clause. D, alienation. Correct answer here is subject to clause. So a subject to clause allows a buyer to take over a loan, making payments without the lender's knowledge and consent. The primary borrower is actually still liable for the debt though. This is different from the assumption clause because the assumption clause means that the person assuming a loan is actually qualified in taking over that loan. Whereas the subject to clause means that the lender doesn't know that someone else is now paying for this mortgage. Question number 17. The most complete title protection is offered by A, an extended coverage policy, B, a standard title policy, C, a certificate of title, D, an abstract of title. Correct answer here is A, an extended coverage policy. So in addition to the standard policy coverage, an extended policy offers protection against unrecorded liens. Abstracts and certificates of title reflect an attorney's opinion regarding the condition of the title and carry no guarantee. Question number 18. The seizing of property by court order as security for a debt or judgment is known as A, attachment, B, alienation, C, capitalization, D, encumbrance. Correct answer here is A, attachment. Question number 19. The successive conveyances affecting a particular parcel of land arranged consecutively from the original source of ownership to the present day owner is called A, estoppel certificate, B, abstract of title, C, certificate of title, D, chain of title. The correct answer here is D, chain of title. So this is, I think, the second or third question we've seen that has abstract of title, certificate of title, chain of title. So when you are studying, make sure you review those chapter summaries. Make sure you know the definitions of important words. So when you get to questions like this, they're easy for you to answer. Last but not least, question number 20. A buyer contracts to purchase a $75,000 home and puts up an earnest money deposit of $1,500. The commission is 5% paid by the seller. The buyer gets a $260 credit for real property taxes paid in arrears. The buyer obtains an 80% conventional loan at 12% interest with 3 points. This buyer needs to give me a call. 12% interest, 3 points? That's crazy. What amount should the buyer bring to closing? A, $15,040. B, $19,913. C, $16,540. D, $15,800. Correct answer here is A, $15,040. Let's do a little math here. So 80% loan on $75,000 means the loan is for $60,000. 3 points, aka 3% of $60,000, which is the loan amount, is $1,800. The buyer gets a credit for $260 and another credit for $1,500. And so that reduces the amount to $15,040. So $15,000 for the down payment, 3 points is $1,800 minus credits of $1,760. As always, thanks for watching these videos and studying with me. I truly hope you pass your real estate exam on your first try. Go ahead and email me directly if you have any questions or if you need help getting started in your real estate career.